Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in our case number CV220425, Perez versus Circle K Convenience Stores, Inc. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time if you wish to do so. If you do wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid undue embarrassment, I would ask those in attendance to make sure your cell phones are off so our proceedings are not interrupted. We have read the briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present our argument today. Our proceedings are being recorded, and so please, as you begin your presentation, tell us your name and the party that you represent. With that, Mr. Abney, you may proceed.
I thank you, Honor. May it please the Court, my name is David Abney. I'm here representing the plaintiff. As always, it's a rare honor and privilege to be here. Sometimes it's even enjoyable. For some reason, I thought oral argument was at 9 this morning, so I got here an hour early, and I've been spending the last hour thinking of questions that will never be asked and answers that will never be given. So I apologize if my brain is a little scrambled.
We appreciate your punctuality, Mr.
Yes, Your Honor. This is an unusual trip and fall case for me because so many of the defenses have been specifically repudiated. The defense repudiated assumption of the risk, contributory negligence, comparative fault, the open and obvious defense, that's out. And they said we're not making any issue about notice, whether we had notice, didn't have notice, that's out too. Their main argument is that there was no duty that was owed to Roxanne Perez, which doesn't make a lot of sense. She was an invitee in the premises, and therefore there was a very strong non-delegable duty owed to her to make sure that the premises were in a reasonably safe condition and to actively search out for any conditions that might need correction to protect her as an invitee. It's sort of sliding in the distinction between dangerous and unreasonably dangerous and saying, well, if you can't prove it's unreasonably dangerous, then you don't owe a duty to the invitee, and I think that's an incorrect kind of analysis. You still owe a duty. You just have to try to figure out where along the spectrum you go from dangerous, and they don't make an issue about that. They say that the trial court correctly found that the condition was dangerous. Their own Rule 30b-6 witness referred to it as a hazardous condition that he would have remediated. He would have moved the display somewhat. He would have made it higher.
Well, because he's not making a legal statement that it's unreasonably dangerous, is he?
Right. No. It would be nice if you could have witnesses do that and say it's unreasonably dangerous, and everybody wins. But that's no. But he is saying that he regarded it as a hazardous condition that should have been remediated. You got two employees who, one of them apologized after she falls. They both indicate that this display was not supposed to have been where it was.
Let me ask you about those employees, because the trial court didn't consider that evidence, at least as I see the record, and one of the questions is whether that was error or not, for her not to do that. And it came in, as I recall, through plaintiff's deposition. Plaintiff said, hey, an employee or these employees apologized and said these things weren't where they should have been. If it was error not to consider that, and if that's considered, though, for an unreasonably dangerous standard, where does that take us?
It pushes you a little bit further on the spectrum of saying that this is, well, it's a jury question, really. It's another factor to consider. You've got all the circumstances. She goes into a store that she knows, of course, although that can't be held against her because they're not saying she's contributory, comparative at fault, open and obvious, any of that.
All those, though, genuinely would be on the question for the jury spectrum, not a question for the court as to duty. Fair?
Right. Well, the reason I talk about the two store employees on the day and then the Rule 30b-6 person is that when we get back down, I hope, and resume this case, then there's going to be an issue of, well, has that been resolved, that it's not admissible or it is admissible? And so I think it's something that the court should take a look at and give us its judgment and decision about whether it is admissible or not. It'll be helpful if it is admissible.
I can understand why you would want that to be admissible. But help us understand your position as to how that helps define duty.
It doesn't.
Okay.
As far as I know. The duty is the one thing that is as clear as can be. In fact, when I went through the reply brief, I decided to try to look at every Arizona case that had ever discussed duty in the context of an invitee to a store, and I think I covered just about all of them. And case after case after case, it's the same thing. There is a duty to the invitee. So, that really should be a given in this case, that there is a duty.
So is it your position that because there's a duty that a business owes to a business invitee, that the issue of duty is never at play on a dispositive motion for a claim for an injury caused that occurs on a business premises?
Right. As long as you can establish...
What case would best support that proposition, that summary judgment or motion to dismiss, for example, could never be at issue on a business invitee case? That could never be granted.
Once you say business invitee, if you've established that the person coming on the premises is a business invitee, then there is a duty. I mean, you can't get away from it. The duty exists. And what you have to do to fulfill the duty, of course, is give it a standard of care.
And the court, from your position, shouldn't look at the parameters of that duty. It's just the fact that there is a duty precludes any motion practice on that first prima facie element of a negligence claim.
Well, the first element you have to establish is what's the status of the person there. Invitee, licensee, trespasser, maybe something else.
Well, let me tell you why my view of those prima facie elements, it seems to me it's duty, breach, causation, let's call it factual causation, then legal causation, proximate causation. Arizona has done us a turn by smushing those two together, and then damages, right?
Those are the four traditional elements of a negligence case.
And what I think this case, the ruling either survives or doesn't based on that first one. But did you read the court as doing something on breach or causation, or was it just duty?
The court misunderstood and was using the word duty very loosely. There is a duty. Once you've established invitee status, then there is a duty, and it's a very strong duty. The nature of the duty is very clear. If you have an invitee, same thing. Trespasser, duties, what you have to do is very, very low, but there's still a duty. You can't set a spring gun or a trap or a bomb to, if you open the door, boom, you're dead. So there is a duty even there. But once you've established the status of a business invitee, there is a duty. And then you go on from there. The court here got mixed up with the distinction between dangerous and unreasonably dangerous, and somehow said, well, if you can't prove it's unreasonably dangerous, you don't have a duty. And that's their theory. But you still have a duty. The distinction is the one that the trier of fact has to make. Is this merely dangerous, or does it slid into unreasonably dangerous?
Well, counsel, so under your view, anytime a customer comes into a Circle K or any business establishment, there is necessarily a duty.
There is a
well, I understand, generally speaking, that a business owes a duty to its customers, but if I'm looking at it very broadly in this circumstance, if it's not an unreasonable danger, then the duty would not extend that far. At least that's how I understand the issue.
Well, the issue that's being framed is along those lines, but the traditional analysis should apply here. First of all, you determine the status of the person that comes in the door. Once you determine that it's an invitee, then you have a certain range of duties. A defense to that would be to say, well, hold on here. This condition was either not dangerous at all, which is not really what they're arguing, or is not unreasonably dangerous, and that's an affirmative defense. And they're smushing that in with duty, but it's really...
So does it go to breach then, in your view, instead of duty?
One more time, Your Honor?
Does it go to breach instead of duty then, in your view?
Right. It's really more of a breach kind of problem.
But you just said that in determining the duty, once they're determined to be an invitee, there's a range of sort of things that you look at. Can you clarify what you mean by that?
Right. Once you've established that it's an invitee, you have an affirmative duty to actually go out and inspect the premises to find any dangers that may be unreasonable, for instance, and to correct those dangers. It's an affirmative duty. You actually have to go ahead and inspect, and then you have to correct.
But is it any dangers or only unreasonable dangers?
The unreasonable dangers, right. You get a pass, and then the jury gets to decide, well, what's the difference between reasonable and unreasonable?
Well, but under your answer to Judge Foster, if there was, for lack of a better term, a reasonable danger, then the duty would not extend that far. So your case will fall for lack of duty under those circumstances.
I'm not sure that that's the cleanest analysis. I mean, the most direct analysis, which is probably the one we should be striving for, is there a duty? Yes, there's a duty. And then what are the parameters of what you have to do in a particular case? And that becomes a question of fact for the jury.
But you always have to, just to say there's a duty doesn't really say much. You have to define what that duty is. And that duty does not, at least as I understand it, does not extend to things that are not unreasonably dangerous. So unless you prove that it's an unreasonable danger, then you've not proved a duty.
The difficulty with looking at it that way is that you skip a step, and the most important step in this is who decides duty, and it's going to be the court. Then the next step is, well, is this condition that was on the premises reasonable or unreasonable? That's a jury question. You can't take that jury question and put it in the hands of a judge unless it's just crystal clear. I mean, the reasonable jurors could never disagree that this was a reasonable or unreasonable danger. The only conclusion they would come to, well, this is a reasonable danger, or they would say, it's debatable. But you need to let the jury decide, unless it's crystal clear that this is a reasonable kind of danger. And this is not a case where it's crystal clear. You've got the Rule 30b-6 representative, for instance, saying that this is a hazardous condition. You've got the court saying it's a dangerous condition. The problem is you need to figure out, well, who decides whether it's reasonable or unreasonable under these particular facts. I mean, she'd been to the store before, she visited many times, but she said on this particular time, she didn't recall the water being in the place where it was. So, I mean, it's going to be up to the jury to decide, well, under these circumstances, has this danger elevated up to an unreasonable danger?
If that's the law, that dichotomy is a jury question, is there anything where a business invitee is injured that wouldn't be then a jury question? I'm trying to think, it's a clear common law claim here, right? No statutory influence. And I'm trying to think where the claim would end pre-jury trial if this is an unreasonably dangerous circumstance.
There could be dangers in the store that you would confront. They have a flashing sign pointing down to the water case, danger, danger. There's certain conditions that are going to be so clear, so obvious that a judge would say, I don't need to let this go to the jury. This is so obvious, reasonable jurors cannot possibly disagree. And that could happen. But this is not one of those cases. This is one of those cases where you've got some interesting facts. You're in a convenience store. She's been there before, but she doesn't remember the water being where it is. You've got store employees and the Rule 30b-6 representatives saying there's a problem here. This is one of those cases that needs to go to the jury for resolution. But one thing that needs to be done, I hope, is to keep the eye on the ball as far as duty, because their argument that there is no duty is just flat wrong. There is a duty, and then, okay, well, then what about reasonable versus unreasonable? And it has to go to the jury for a decision in a case like this.
So duty is not a question of law then. It can be a question of fact. And maybe I've misread Gibson. I certainly could have misread Gibson. But I thought they make it quite clear that duty is a question of law.
Well, it's always refreshing to come here because we get back to basics so often to resolve these cases. Duty is always a question of law in Arizona. It used to be you worry about foreseeability and you get fact questions before you get to duty. It was a real mess until Gibson, straightened it out. And everybody now knows duty is a question of law for the court. And here there's no question. There's no question at all about duty. We all know what the duty is. It's very strong, very clear. The question is this a reasonable danger or unreasonable danger? If they get a pass if it's a reasonable danger, and they don't get a pass if it's an unreasonable one, and it's for the jury to make that distinction.
Counsel, let me ask you, you cited a couple of illustrations from the restatement second of torts 343A. And those look to me to focus on foreseeability, but help me out. And because that restatement, predates another restatement third of physical harms, which I'm thinking says somewhere that it, supersedes restatement second. And does 343A survive Gibson in Arizona?
Yeah. Did it survive Gibson?
Yes. Help me. Those are sort of two questions. Does restatement third of physical harms, supersede restatement second of torts? And then secondly, if the answer is no, does 343A in the second restatement survive Gibson?
I don't think anything entirely survived Gibson. I think the restatement still provides some reasonable guidance on where we need to go. As far as the third restatement, buried somewhere in it, there's a little statement saying this supersedes the second restatement, and that's just not worked out in Arizona.
Well, and it's my recollection that restatement third says that, and I'm glad we're on the same page there. What that means in our state is fairly a different question.
No, I cited the restatement and as to provide some guidance of where it needs to go, but to my mind, this is a fairly straightforward case. There is a duty, and we know what the duty is for invitees. It's very strong, very clear. Inspect, maintain, improve, correct, warn. All those things are great. And then you get to a question in this particular case, is the condition reasonable or unreasonable as far as dangerous goes? And then the jury gets to decide that. My wife is painting the ceiling in our house soon, and I've discovered there are 300 kinds of gray. And everyone's different, and everyone looks different, too. I mean, it's bizarre, all the names they have for these. Well, the jury has to decide here where the shade is, and I submit to you that this is a jury question.
So I'm just going to stop you because the question that I have is, in Circle K's pleadings, they talk about the Agar decision from this court. It's not binding, but you haven't mentioned that at all. Do you think that this court got that decision wrong and that we should go the other way? How do you view that case?
I discussed it in the briefing. I think in the reply brief, maybe the opening brief. I called it the mineral cases. There were two mineral cases, pebbles or rocks or something. It's a bit different because it's here. Roxanne Perez is saying, I've been to the store, but I didn't know. There was something different. I didn't notice this thing. The other one, the people were saying, well, yeah, it's rocks. We've seen it before, fine, and boom, they go down. I think there's a fundamental difference there in perception. In one, I'm not sure the court should have decided those as a matter of law, but here, this is different. She's coming into an environment that is the same but different, and she's a distracted. She's a shopper in a place that has all kinds of displays.
But my memory of that case is that the plaintiffs in that case said that they did not see the gravel and acknowledged that they didn't see it. But in this case, Ms. Perez indicated that had she just looked down, she would have seen it, which is a differentiation between these two cases. So it sort of indicates that she knew it was there.
Well, that's a jury question. I think the facts are that she didn't know it was there. She was not looking down when she was walking, like most people don't. She was focused on her mission to get the ice cream, to get out, in what is inherently a distracting environment. She didn't notice it. When you start about it, you get a very interesting problem here, because when you start about, well, she should have taken care of herself, she should have looked down, well, you just walked right into comparative fault, contributory negligence, assumption of the risk, open and obvious danger, all of which they repudiate. They said, these are not our defenses in this case. I don't know what they're going to do if this case gets remanded. I don't know if they're stopped to assert them. I assume all the defenses will come out of the closet at that point. But for this appeal, they're just not on the table. So whether she was looking down or not looking down, whether it was open and obvious, it's just not on the table here.
But I go back to some of your original statements where you talked about finding a duty.
Right.
And you have to go to, that's our job, is to define whether there was a duty or not.
Right.
If there was a breach, that's an issue of fact. But in determining whether there was a duty or not, you talked about determining whether it was unreasonable or not. So where is that line drawn as to when duty stops and we get to breach?
If I have said that, I have stepped on my foot, because
And I could have misunderstood, but that's why I'm clarifying.
My eloquence has limits. There is a duty, unquestionably a duty to an invitee, very strong, clear, lots of elements to it. But what they're raising here is, okay, it's not dangerous condition. It's not an unreasonably dangerous condition. We'll give you it may be dangerous, not unreasonably dangerous. Well, you've got a condition there that the jury has to decide. It's a fact question at that point.
Mr. Ebney, time goes quickly.
That's okay.
We'll give you another 2 minutes for rebuttal,
Thank you,
and
Mayor.
I'll add 2 minutes for the appellee's argument as well.
Fair is fair. Thank you,
Thank
Ron.
you. Thank you.
Appreciate it.
Mr. Causey, and you do have 22 minutes, so, although obviously if you choose, there you go, thank you.
Entire discussion of Wade Causey, I apologize on behalf of Circle K. We got going into that and I skipped to that. So far, in 22 minutes of discussion, I think Judge Howe's the only one that stated what the duty is. Let's go, it's in the jury instructions, first sentence. It's been around a long time. The duty is as to any unreasonably dangerous condition of which the proprietor has notice, you must remedy and or warn. And that's been here for decades, way before I was. And that's the duty. And the reason Ager, I don't want to misspeak, but the reason Ager, Hagen versus Sahara, Prius versus Sambos of Arizona, the reason all those decisions are not wrong is because there's two prefatory conditions to a duty. We do not follow, it's been specifically rejected, negligence law in premises liability situation. Negligence has a piece of it when you get to certain reasonable aspects. It talks in language of negligence, but it's been specifically rejected. Some jurisdictions have completely gotten rid of premises liability and rolled it into just straight negligence. We have rejected that to date. Now, I'm telling the court what the current status of the law is. I'm not suggesting I agree or disagree with it either way. Doesn't matter. It is what it is. I follow it. And so did the court in this instance. If the court is wrong, then I know of at least 10, 15 cases out there that are all wrong, including Ager, which just came out in 2021. Now,
Counsel, I am intrigued though. I've always understood that duty is a question of law for the court. The question I have though is whether something is unreasonably dangerous or not. It seems very factual rather than legal. So how do we resolve that apparent inconsistency?
and that's a very good question, and I'll go back to some additional very basic premises liability law that's been in place for decades. Arizona, just to summarize and state it as simply as possible, you don't get a pass. Okay, it starts with the premise that people are supposed to watch where they're going. We don't get to just tell our children when they're growing up, hey, watch where you're going. As adults, our law says you need to watch where you're going. So we start with that premise, okay? The second premise, which actually, Your Honor's talking about 343, I don't think that all of it survives Gibson. I agree with counsel. I don't think the foreseeability parts of it survive Gibson, but I do think there's still other parts of it that may. And that would be, start with the premise that you have to watch where you're going, okay? As an invitee, we still are expected not to run into the pole, okay? I'm not expected to trip over this thing, okay? It's a light, fine, can see it. That's the initial legal premise, which is why we don't always have a question of fact, okay? The second one is, if we assume that, is there evidence, not just argument, not just a suggestion of counsel, is there evidence that the proprietor knew that that invitee might not be able to protect themselves from this specific condition for some reason? And most of the case law in Arizona tells you that the type of evidence, and again, I don't know if this runs afoul of Gibson, but it is, has there been any prior incidents involving this condition? That's what most of the cases talk about. And of course, as Judge Thomas said a minute ago, that starts leaning a lot toward foreseeability, but I don't think you can get rid of it.
Let me ask you, is the permutation for that then, the proprietor has no liability for the first injury, but the second and subsequent there is? I mean, is it the first dog bite sort of rule?
It's not. And let's go back to premises at the beginning. If you talk about, what's the difference between the proprietor and the invitee? Well, the presumption is the proprietor knows their property better, okay? They are there, they walk around, they see it. But the trick here is most of those conditions, and some courts specifically talk about it in the written decisions, there's a certain element of deceit to it. It's hidden, okay? I can't remember the name of it. It's the black carpet case at the top of the stairs, whether or not it was deceptive, the step. There has to be something hidden or deceitful about it. It can't just be something in plain sight, plain view, that you trip over or run into. None of the cases have acknowledged that that's something that can be an unreasonably dangerous condition. And I tell everyone when they ask me, well, what's the difference between a dangerous condition and unreasonably dangerous condition? I said, a curb's a dangerous condition. Trust me, if you're not paying attention, you will trip over it, or as you step down, you'll lose your stride, okay? But we don't paint every curb in the state of Arizona yellow.
Let me ask you, and I understand what you're saying, but let me ask you about Tribe versus Shell Oil, right? That's the case where, and roughly, mother uses a bathroom in a gas station, has children there near a busy street, and I can't quite figure from reading the opinion exactly what happened, but there was a step down and then a step up, best I can tell. And summary judgment's granted for the defendant there, and our Supreme Court says no, that needs to go to the jury. How is this case materially different from that one?
Because the testimony was it was deceptive from the angle that plaintiff was walking from. And the plaintiff testified, I could not see it and I was looking where I was going. That's the distinction.
Okay.
I mean, it's that simple and straightforward. Here, the plaintiff testified, and the trial court did a really good job of setting it out, and I've got it here. Got a little off. The plaintiff, this is on page 2 of the trial court's decision, and right after it discussed Tribe versus Shell Oil, and it's paragraph 3. The plaintiff had testified at her deposition that she saw the case of water she tripped over after she fell. She had no trouble seeing it, and if she had been looking down as she walked around the end of the aisle, she would have been able to see the case of water. The lighting in the store was sufficient. All plaintiff's testimony. That takes us back to the original premise. In Arizona, you have an obligation, a duty, even as an invitee, to watch where you're going. To put it simply, I mean, that's what it is. It sounds kind of straightforward, but that's the reality of it, unless there's evidence to the contrary. Now, the other thing in the case you were talking about, the Tribe case, I don't remember if it's cited or discussed 343, but clearly in my mind, it would have been at that time applicable, because it would have talked about the proprietor from the direction plaintiff was walking and the inability to see it. The proprietor, that's something, since they're more familiar with their property, maybe a jury question at that point for them to decide that. We don't have any of that here. The most interesting part of this is plaintiff never testified to anything, but I just wasn't watching where I was going. That was it, which is Ager, and several of the other cases, Prius. Now Hagen, they said, I saw the pebbles, thought I'd be fine walking through them. It's a little different. And Prius actually turns more on notice, which is what I was saying earlier. There's two elements.
So for something to be unreasonably dangerous requires evidence to that effect. Then, so the trial court is making, it sounds like almost a factual determination there. Which concerns me, just given what I understand of Gibson.
I think what the trial court was doing in this case is saying, hey, where is any evidence of that? Because we obviously have a burden of proof issue. Plaintiff has to show it's an unreasonably dangerous condition. Where's the evidence that it's more than a dangerous condition? A lot of things can be trip hazards, okay? But where's the evidence that shows it's more than a dangerous condition or a hazard? It's an unreasonably dangerous condition. And the courts have defined whether or not it's unreasonably dangerous or not, and that's whether or not it presents an unreasonable risk. And if it's plainly visible, the courts have routinely stated, without any other evidence, okay, like getting into the 343 things of that nature, or 10 people earlier that day tripped over it, you know. Yeah, so I don't think the court's weighing the evidence. I think the court's looking for any. And I think that's a distinction.
So I guess I'm slow to the party here, but so the question from your perspective is there evidence from which a jury could find that it was unreasonably dangerous?
Yes, yes.
And that's a legal question. That's strictly not a factual question, then.
It could be if there's evidence of it.
Well, but I guess that, to me, that's the test then. Is there evidence for which a jury could find it to be unreasonably dangerous, right?
Exactly.
Then for us, then for the court, in the first instance, to decide whether it is or is not unreasonably dangerous.
I didn't catch that last part. You want to
I guess, are we, and when I say we, I mean the court broadly, are we deciding whether something is unreasonably dangerous or not? Or are we just deciding, is there evidence from which a jury could find it to be unreasonably dangerous?
The latter.
Okay.
The latter. Which is why I thought it was very important to start off, once we got past some of the earlier questions, with what the court stated here in the factual paragraph, page 2, paragraph 3 of the ruling. And that's why the court's decision's correct. There wasn't any evidence showing it was unreasonably dangerous. The only evidence presented to the court on the record was that it was, and I like to use this phrase, I read it in a case years ago, I don't think I cited it here, plainly visible. And if the court wants me to, I can get into all those. The reason that the defenses, obviously we'd still have them at trial. We didn't argue that we're waiving all those defenses. We're saying they weren't raised on the motion for summary judgment before the court. The only issue raised in the defendant's motion is whether or not it was an unreasonably dangerous condition. Notice wasn't raised. So all these other issues, whether or not they still exist or not, I don't know. They haven't been litigated, though. We never got to that point. So I'll forego discussing them because of that. Because
Counsel, if you would, I'd appreciate your view on the evidentiary issues, the statements that Ms. Perez testified to that the Superior Court appeared to disregard.
Oh, no, the court specifically disregarded them, stated so.
Was that correct?
As to the employees, I do believe it was correct, but I don't think it matters, because...
Help me understand, before you get to why it doesn't matter, help me understand why that isn't an admission by a party opponent.
Because the plaintiff never established admissibility under 801. There's several factors under 801. It was never briefed or presented to the court, the exception to the hearsay.
And that was, though, part of the summary judgment briefing, correct? Was there a motion to strike that testimony or a motion to preclude?
No, there was an objection to the
Okay.
statement of facts based on hearsay.
Okay.
There was a written objection. I did that in a response to the plaintiff's statement of facts. So we filed our motion for summary judgment. They responded with a statement of facts. Our reply objected to it on the basis of hearsay.
So it's preserved, and you view her ruling as correct?
Yes, yes. And without even getting into the substantive issue of whether it's correct or not, the plaintiff never established its admissibility under 801, and of course they're offering the evidence. They have to establish its admissibility. So it was never established at the trial court level. There's no record of an 801 analysis. Wasn't briefed. Now, if you want me to tell you whether or not I believe under 801 they could or not, I don't believe they could, because I don't believe these front-level employees are authorized by the company to speak to those matters. Then we get to the more important issue, I think. Does it really matter? Well, their testimony was that, we're sorry you fell. We even have case law in Arizona that says that's not an admission. I've seen those cases. But the statements from them was, we normally stack the water higher. Well, everybody does. The Coca-Cola display at the end of the aisle at Fry's is always higher until people buy some, and then it goes down. That's not an admission. That doesn't reach, you can't take that and say, okay, well now, that takes it into unreasonably dangerous territory, because they say it's normally stacked higher. It's not an admission under the substantive law is the problem with it. So stays hearsay. I think the trial court's decision, whether it was based on the failure to properly establish its admissibility under 801 by the plaintiff, or whether it was a substantive, and we don't know. The court just said, I'm not considering it. I think it was correct. So, if there's no more questions, that's all I have.
Thank you, counsel.
All right, thank you.
Appreciate that. Mr. Abney, rebuttal.
Sure, Your Honor. Just a mathematical, he's got 6 minutes and 5 seconds, so, and I've got 2 minutes and...
Actually, I have 1 minute and 55 seconds. So.
I didn't think that would work.
No.
I keep getting statements from my learned opponent about things like you have duty to watch where you're going, things are plainly visible, you need to watch out for. Those are all things that they've waived up here. They can't be part of this. This is open and obvious, contributory, comparative, assumption of risk kind of arguments. They can't really factor in here because they've been waived. I was the one who cited and quoted the unreasonably dangerous jury instruction, and its notice of unreasonably dangerous condition is what that jury instruction is about. The jury instruction committee was baffled by what to do about unreasonably dangerous. They decided we're not going to define it. They said, quote, definition of unreasonably is not provided because the parties are expected to argue what unreasonably means in the context of their particular cases. And they felt, they quote, felt that jurors understand the difference between those conditions which are dangerous but do not impose liability as opposed to those that are unreasonably dangerous.
So we are, the talk was deciding whether there was evidence from which a jury could find it to be unreasonably dangerous, and said no, there doesn't seem to be evidence from which a jury can make that determination. And what's wrong with that?
Nothing, I think, if I understood your comment correctly.
Isn't that what happened here then?
Well, what happens here is, the duty question is so easy to resolve. Are you an invitee? Okay, there's a duty. And then you get to the dangerous versus unreasonably dangerous. Courts should not be in the business of deciding that unless it's crystal clear that reasonable jurors could never disagree about it. And then you get into business.
But we're not discussing that. We're just deciding whether there was evidence from which a juror can make that determination.
Exactly right. And that's what we've got here. We have some evidence. It's not the strongest evidence in the world, but if it was the strongest evidence in the world, this case would have settled and we wouldn't be here. But there's enough evidence there to go to the jury, and they could take the bits and pieces that are presented, the employees who not only apologize, but say, this is not how we normally do it. And then the Rule 30B representative, who was very candid about some of the key points, and he's speaking for the corporation, no question about that. So there's enough, oh my gosh, I ran out of time. There's enough here to go forward. Thank you for your time.
Time goes quickly. Counsel, thank you. Thank you for your presentation today. Thank you for your written materials. We'll take the matter under advisement. We'll issue a written ruling in due course. This session of the court is adjourned. We'll stay on the bench while we set up the courtroom for the next oral argument. Thank you, and have a good day, gentlemen.
Thank you.